You are on probation. Probation is a contract. So even though your attorney, the state, and probation is saying SATA, I could still say I'm sending you to prison for 5 years.
He walked out of court-ordered treatment without permission. Now he's back on a motion to revoke and facing up to 5 years in prison.
All right, the court is calling 2022 CR 0491, State of Texas versus Jeffrey A. Adames. Could I have parties announced for the record for the state?
Travis Banks for the state of Texas.
Defense?
Jay Moritz, Your Honor, from Mr. Adame.
And are you Mr. Adame?
Yes, ma'am.
Is your last name Adame or Adames?
Adames.
All right. I'm going to show you what's entitled Motion to Revoke Community Supervision. Did you review that with your attorney? Did you understand it?
Yes.
Are you the same Jeffrey A. Adames who was placed on community supervision for the offense of assault, family choking, strangulation on February 23rd, 2022 for a term of 5 years? Is that you?
Yes, ma'am.
State?
Violated condition number 28 on or about the first day of May 2023 in Bexar County, Texas. The defendant, Jeffrey A. Adames, did then and there fail to comply with the rules, regulations, or instructions of the Lifetime Recovery Substance Abuse Treatment Facility, and that the defendant prematurely departed the program without permission in violation of condition number 28.
So much. And Bashan, he's going on 28.
Yes, Your Honor, thank you.
To that, how do you plead? True or not true?
True.
State?
And the state would waive and abandon the further allegations.
All right. Did you understand by pleading true to violation of 28, the court could find it true, grant the motion, and sentence you up to 5 years in the prison and up to a $1,500 fine? Did you understand?
Yes, ma'am.
Knowing that, do you still wish to plead true to violation of 28?
Yes, ma'am.
Counsel, any objections to the waivers of the other allegations in the motion?
No, Judge.
All right. Is there a recommendation?
Yes, ma'am.
The recommendation and the agreement of the parties, should Your Honor choose to accept it, is to deny the motion and alter and amend the defendant's conditions for SATIF with aftercare, and have the defendant complete that drug treatment.
All right, is that the
Yes,
recommendation?
my understanding is that it was held in abeyance if he didn't comply, and that he is agreeable to it and wants that treatment, Judge.
All right, probation?
Yes, Your Honor. The recommendation would be for static with the aftercare, and if he does not want to do that, I recommend revocation.
All right, you'll raise your right hand. Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, ma'am.
You can lower your hand if you'll state your name for the record.
Jeffrey Allen Adames.
All right, why did you leave Lifetime Recovery?
My father was diagnosed with brain cancer. I had to help because I get disability retirement. So he was going to lose his house. So I decided to, my two brothers weren't working. So I decided to leave so I can use my disability retirement to help him out with his, till he had the surgery. And then when he went to recovery in University City, he started the recovery. My brothers got a job, so I was able to leave. And I was working on trying to get some money so I could turn myself in, which I did in the 13th of last month.
Yeah, why don't you pick up the phone and call probation and say, my father has cancer and I need to help him?
I freaked out. I mean, I was just, I was just real distressed. I mean.
No, how old are you?
I'm 50 years old.
No, it's easy to pick up the phone and say, my father has cancer, I need to go help them. And then if probation would have said, no, you can't do that, then you know what would have ended up happening? I would have got an email from probation and they would have sent it to me and said, his father is ill, he would like to go be with his father. And then you know what I would have said? Have him come in and we would have discussed it. And maybe I would have let you take care of issues with your father. You are on probation. Probation is a contract. So even though your attorney, the state, and probation is saying SATA, I could still say I'm sending you to prison for 5 years.
I understand.
Do you understand?
Yes, ma'am.
So now what has happened? You're still in the same situation you are. Now you're starting all over. When Lifetime Recovery, you probably would have been finished with it by now. Now, instead, if I follow this agreement, you're going to be in custody and wait for transfer to SATA. All because you don't pick up the phone and call anybody. And Lifetime Recovery and all of these treatment programs are supposed to teach you how to deal with your problems. And dealing with your problems are not supposed to be, I'm not going to follow the rules. I'm going to throw my hands up. What if I had a problem and I said, in the middle of this, I have a problem and I just leave. I don't tell you guys anything. And everybody just sitting around here like, what happened to the judge? What's going on? If someone had called me right now with an emergency, if my mom or somebody would call and say, it's an emergency, we need you back home. You know what I'm going to do? I'm going to say, everyone, excuse me for a moment. I'm going to get on the phone. I'm going to call the powers that be and say, I need a judge. I have to leave. I'm going to tell everybody here, everyone, I'm sorry. I need to leave. I need to get a flight. I need to work on that and go home. I'm not just going to leave. And then everybody's like, what do we do now? And in your case, when you just drop off the face of the earth, you know what the what do we do now is? File a motion to revoke. All right. How much longer did he have in lifetime recovery? Will lifetime recovery accept him back or no?
Your Honor, that would be something I'd have to research.
All right. So this is what I'll do. If you want, I will sentence you to prison for 2 years, or I will send you to SATA. And if lifetime recovery will accept you back, then it'll be lifetime recovery if they accept him back. If they won't, he'll go to SATA.
At this point, I really don't think lifetime recovery would be the best option. I think we would need something a little more structured.
All right. So it will be SATA. So you can go to prison for 2 years, or either you can go to SATA. Which would you prefer? All right. I'll deny the motion. Alter and amend conditions.
Yeah.
To include SATA. Followed by aftercare. And I'm going to want the UA hotline upon release. And that's to be until further notice. Is there anything else you need from the court so that I won't see you back up here again with the motion to revoke? Probation, is there anything else he needs? All right, good luck to you.
Thank you.
You're welcome.
Thank you, Judge.
You're welcome.
Counsel. Could I have my paperwork?
Oh, no, I'm being told he stuck his finger in water and in the testing, which I find very suspicious. Yeah, no,
The other number two really bad.
nobody does that.
And I was trying to take.
Court is calling 2023 CR 0889 State of Texas versus Stephen Wayne Walbarker. Could I have parties announced for the record for the state? Defense.
Ron Ross for defense.
Are you Stephen Walbarker? You entered a plea on June 15th, guilty to count 2. According to the plea bargain agreement, punishments to be assessed at 8 years in the prison. The state is silent on your application. Have both parties had a chance to review the PSI report? State?
Yes, Your Honor.
Defense?
Yes, we have, Judge, and by the way, it's a capital H.
Ah,
Yes, and state is silent, Judge.
all right, if y'all want to, oh yeah, it is a captivate. Okay. And the state is silent. Have both parties had a chance to review the PSI report? State?
Yes, Your Honor.
Defense?
We have, judges, just one correction or
Yes.
in the TAP evaluation down about toward the end of it, said that he's continued to use marijuana since he was arrested, and he says that's not true. He said since he's arrested, he was using it before, but since that he hasn't used it. That's what he tells me.
Well, we can't get a UA because
I know.
he stuck his hand in the cup. Nobody does that. I don't know anybody who would purposely or accidentally stick their hand in a cup of urine.
I just did, but there was no urine, ma'am. I just grabbed the cup. I didn't even.
Yeah, nobody does that. You wasted a UA in this court.
I can,
So, counsel, anything you wish to say on behalf of your client?
Judge, I would say that he's 55. And I think his report, he's got child support obligations. He lives, I don't know that he's not diagnosed as mental slowness, but it seems to be. And his jobs, he's not had real good jobs right now. He works at a cook, but he is employed. He's been employed, and I don't know that at this point in time, sentencing the prison is going to really will really make much difference or correct his behaviors. I would ask you to make him do outpatient treatment. Let's see if give him a chance. I mean, I agree with you. I think it's kind of ridiculous what he says, but give him
Oh,
outpatient.
I would tell you, counsel, outpatient treatment is going to be out of the question. He's going into custody today. So either he's going to prison or either he's going to treatment. Those are his choices. Either he's going to safety. I know they're recommending SADC, but for someone to purposely invalidate a test, that tells me a little bit where he is with regards to his sobriety. So either you have a choice. You can go to safety or you can go to prison. If you wish to go to prison, I will sentence you to 4 years. Which do you choose, prison or treatment?
I'll take treatment.
All right, the court will sentence you to 8 years in the prison. Thank you. Suspended and probated for 8 years. Take in consideration 2023 CR 0888. Thank you. Got to sentence you to Safe P, followed by aftercare. There's to be proof of employment within 45 days of release. There's to be no employment as a home health care provider or with minors. There's to be the UA hotline upon release. There's to be no unsupervised contact with minors. Regular reporting by Zoom or in person. Field visits 1 time per month for 4 months. And if everything is going well with the field visits, probation, I'm going to want random field visits after that, and you'll be able to pick how often you wish to do that. There's to be 200 hours of community service restitution. Probation, is there anything else he needs? Is there anything else you need from the court to be successful?
Judge, anything else?
Anything else you need from the court to be successful? All right, I'm going to show you what's entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review that document with your attorney? Did you understand it? And did you sign it?
Yeah, yes, ma'am. Oh, yes.
All right. You do have a right to appeal since there were issues raised through pretrial motions. But however, this is a felony conviction. You're not allowed to own or possess any weapons or ammunition, any body armor or anything of that nature. Do you understand? If you have a question over what a weapon or ammunition is or body armor, you'll need to speak to an attorney. Do you understand? We can go off the record. Mr. Wahlberger, here's the thing. When I ask for people to do UAs, sometimes I know that people are going to come in and they're going to be positive. I can see the signs when people are going to be positive. The reason why I'm asking is because I'm trying to determine 1, your level of truthfulness, and 2, where you are in your sobriety. And when you are dishonest with me about your sobriety, you know what that tells me? That tells me you need to be in somebody's inpatient treatment. So you're going to inpatient treatment because of you. All you had to do was take the UA instead of sabotaging the UA test. You understand?
Yes, ma'am.
All right, good luck to you. So are you the attorney on all these cases or just one?
Just one, Your Honor, I believe.
Who is the attorney on the other cases?
I believe Mr. Castañon was appointed on this, Judge, on these cases. There seemed to be, sorry, Judge, something got a little convoluted with the jail when I made the bonds for Mr. Rangel.
Ah. All right, Mr. Rangel, you understand that he was the bondsman, not to be your attorney? All right, are you going to have any objection to his withdrawing?
No, Your Honor.
Okay. All right, thank you.
Thank you, Judge.
All
May I
right,
be
it's-
excused.
Yes, and Mr. Rangel, you're actually set to be back in court on August 15th. Okay. All right, you have any questions about anything of the process? All right, we'll have you brought back on August 15th. All right, thank you. All right, so we're here for discovery. Where are we on discovery?
Judge, I think we're in good shape. We're just gonna confer on an offer and would ask for another pretrial.
All right, so has an offer been tendered?
No, Your Honor.
Is that going to be tendered today? Or is that possible to have it tendered today or no?
It's possible.
All right, if it's not, just let me know. All right, so this is what we're going to do. Ms. Ferguson.
Yes, ma'am.
On Michaela Johnson, I need a 30-day reset. At that time, I'm going to need an acknowledgement of discovery and an offer to be tendered. And then after that, I'll give you a plea deadline date.
Thank you.
Judge, additionally, we
Oh,
have.
just 1 second.
Yeah, sure.
One thing at a time, then we'll take up the
No
other
worries.
thing.
Can do September 14th.
All right.
That's good.
All right, so if you'll get the reset form ready for that, and let me just write this in the phone. All right. Then in two of the cause numbers, I have a motion to modify conditions of bond. Have both parties had a chance to review those?
I have, the state has, and reviewed with Mr. Hancock, and we're not opposed to it if that is verified. Mr. Hancock was sending me an email. I have not received it yet. Verifying that she is enrolled in high school. And an alternative campus.
So Judge, I certainly can show Mr. Garahan, we do have verification. She is 17 years old, lives in the Northeast School District, Roosevelt High School. Through her mother and planning for her senior year, they have sent her to some alternatives campus for Roosevelt High School. So we're just seeking relief from the monitor so she can get up at, I think, attend at 7:45 a.m. and be home by 4 p.m. And Judge, if there's more cause numbers, I would like that to apply to all of them. You made a good point. I filed.
All right, you also have the cause number ending in 3850.
Would you add that, Your Honor, to one of the,
Yes.
thank you so much.
All right, we're going to go on the record. Court is calling 2023 CR 3848, 3849, and 3850, State of Texas versus Michaela Johnson. Could I have parties announced for the record for the state?
Jason Garahan, Your Honor.
Pat Hancock for Miss Johnson.
And are you Miss Johnson?
Yes, ma'am.
All right, the court is in receipt of motions to alter and amend conditions of bond. State, are you ready to proceed?
Yes, Your Honor.
All right, defense, you may proceed.
Judge, we filed the motion to amend the conditions of bond as Miss Johnson is on full house arrest GPS. Her mother is present today. And she's 17 years old and she attends Roosevelt High School through Northeast Independent School District. Her mother has been informed that due to these arrests, she would be sent to an alternative campus for the immediate future. And we are just asking permission for her to be able to attend school at 7:45 a.m. I think it's released at 4 p.m. So she'd be home thereafter.
All right, state, any objections?
No objections as long as the device remains in place and the curfew is enforced, Your Honor.
All right. So I'll grant the motions in each cause number, but she is allowed to attend school upon verification. So you need to provide verification to her pretrial services officer.
Done, Your Honor. Thank you.
So, Ms. Johnson,
Yes,
here are
ma'am.
the rules. These are your school hours. That does not include any activities that may or may not be happening. If you detour from your school to somewhere else, what's going to end up happening is I'm going to get a report. Your attorney is going to be called in here and you may end up being taken into custody. You understand?
Yes, ma'am.
All right, any questions from anyone?
No, Your Honor.
All right, thank you.
Thank you, Your Honor.
All right, court is calling 2022 CR 3040, State of Texas versus Jeffrey Kesey. Could I have parties announced for the record for the state?
Cross Banks of State of Texas.
Defense?
Your Honor, T. Christopher Lewis on behalf of Jeffrey Peasley.
All right, the court is in possession of a motion to modify conditions of community supervision. Defense is asking that the no unsupervised contact be lifted. Is that correct?
That's correct, Your Honor.
All right, state, do you have any objections?
Yes, because of the nature of the charge. it's an object.
All right, Mr. Kesey, can you raise your right hand for me, please? Do you solemnly swear affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, ma'am.
All right, you can lower your hand. Who all lives in the home with you?
Now is my children, my wife, and our former nanny.
All right, so why can't the former nanny, the wife supervise?
Oh,
Yes,
My former nanny is moving out
okay,
and find her own place. And my kids got accepted to a science and technology school outside our district, and it's close 7 miles from my job. It's about 35 miles from my wife's job, so I'll just drop them off, pick them up from school.
Your Honor, I might add, during the sentencing process, you indicated that you did not want, at that time, his wife to supervise. You wanted the in-laws who were living with him to supervise and not
Mhm.
just the wife. So that's why she couldn't do it.
all right, state, do you have any objection to the wife supervising?
If it is the wife supervising, no, the state has no objection to that, Your Honor.
All right, the wife can supervise, but the no unsupervised contact is to remain. All right,
Thank you, Judge.
all right, yes,
I do want to point out that Mr. Smith stated his spiritual.
okay,
That for CPS and
thank you, probation.
Thank
All
you.
right, so this is what we're going to do. Because I know school is starting. I want to see how this goes with all of the confusion and miscommunications that sometimes happen when children are in school. So if you'll come back in November, because that will give you September and October to see how people are handling different issues, then the court will reconsider. But for now, the court will allow the wife to supervise.
Thank you, Judge.
And what did you learn from parenting classes?
I learned a lot. I learned different and better choice making when it comes to my children. And I've learned how to take time to react instead of being just immediate reacting from my frustration. And I learned just how to be a better and a more involved father.
And I'm sorry, what is your wife's name?
Shyla Kasi,
Spell that.
SHYLAH.
All right, is there anything else?
Nothing further, Your Honor.
All right, thank you so much.
Thank you.
Judge. I was blessed.
All right, so it appears that Mr. Beecham is not going to regain competency.
No, Your Honor, that's what the evaluation came back with. After that evaluation was done, Judge, the state, and by the state, I mean Miss Sally Ungerfer, requested that my client do a DID evaluation through ACOG. We had that evaluation on July 12th. The doctor has 30 days to turn it in. It's just shy of that. I confirmed with the clerks at the magistrate court that they still have not received the results of the DID evaluation. And until we get that back, the prosecutor that I'm conferring with will not kind of have an answer on how to resolve this case, Judge.
All right, so Mr. Beecham, usually this is the way it works when there are competency issues and persons are not regaining competency. According to the law, you will sort of be on probation for whatever the range of punishment is for your offense. So this offense is 20 years. So unless somebody decides to dismiss your case, that means we're going to be with each other for 20 years. Well, I probably won't be here for another 20 years because I'm in the twilight of my life. but somebody will be here. So this is what we will do. We will just do check-ins. So are you able to come down to the court every now and again?
This one.
All right. So what we'll do is we'll just set him for a check-in. What do you think is appropriate, counsel?
Judge, if whatever the court feels, if you would allow 60 days, Judge.
Okay. Is his mom here?
Yes, Judge.
All right. Could his mom come up, please? Hello. All right. So I know you work.
Yes, ma'am.
So are you able to Zoom?
Yes, ma'am.
And will you be able to Zoom with him?
Yes, ma'am.
All right. So let's do this. And I'm going to be dependent on you because I'm trying to do what's right to help him, and the state is trying to do what's right, and his counsel is trying to do what's right. So I'm going to schedule you all sort of like what they would do if you were in Judge Carruthers Court, which is the mental health court. It would be nice if I could transfer this file to them. So every 90 days, we're going to have a Zoom meeting. If you feel that he's off his meds or something's going wrong, let us know. Because what I can tell you is when people are off their meds, things quickly go downhill, and then the problem becomes a bigger problem than what it otherwise would have been. So we're going to set him every 90 days to check in, to make sure he's doing okay. And mom, if he's not doing okay, if you will let his attorney know, and attorney, if you'll let me know. And again, if he's off his meds, my intention, and I'm sure the state's intention, is to make sure he gets back on his meds and everything is okay.
Yes, ma'am.
So, Ms. Ferguson, on this case, can I have a 90-day reset? Oh, you guys will be here on my birthday by Zoom. Okay. People don't care about my birthday. They're just setting things on my birthday. That's okay. All right. Yeah, it's, I walk in the land of the living and the land of the dead, since this is the Day of the Dead. All right, so we're going to come back on November 2nd, and you all, I'm writing on the docket sheet that they can appear by Zoom. And counsel, just make sure that you get the Zoom link beforehand so they can have it.
Yes, Your Honor, and just so the court's aware, my client's on a shot for he's on an injection, so
Okay.
he's been consistent with meds
All
the
right.
entire time.
All right. And Mr. Beecham, is there anything you need from the court?
Well, I was asking if I could get off the monitor.
I tell you what, let's take that up in November, because I need a sort of track record to see how you're doing. But I'll still let you do things while you're on the monitor, okay?
This one.
All right. So let me just see where we are, and then we'll think about it, okay? All right. Thank you so much. And look at him coming in here with the Notre Dame thing, not realizing I'm an LSU Tiger. All right. I'll see you all back on November 2nd by Zoom.
Yes, ma'am.
All right.
Thank you very
Thank
much.
you. You're welcome.
Final result: no trial, no prison, but the case stays open for up to 20 years. The court orders 9-0 day Zoom check-ins, medication monitoring, and continued supervision. This is the system balancing public safety with mental health reality. Like, share, comment, and subscribe for more courtroom breakdowns.
All right. So we're here for discovery. And the last time we were here was in June. DNA issues.
Yes, Your Honor.
So where are we?
I just spoke with Mr. Powers. The buccal swab and everything was obtained on July 3rd and then sent to the lab by July 10th. I just reached out to the lab this week. It will probably take 3 to 4 weeks for that to come back, which I was happy to hear that it may come back pretty quickly. And then I think at that point, then all the discovery, it seems, would be attained. There's some other little pickups in here that the court may or may not be aware. There might be a co-defendant that might be charged also. I spoke with Mr. Powers about that also. So plea negotiations probably beginning here in the next, this next setting
All right. So
possible.
I'm going to give you all a reset for 60 days. And then if you want to come back before then, Mr. Powers, you can set it before then. If you have your information before then, you can come back before then. Because I know DNA evidence, sometimes it's a little iffy. The lab thinks something's going to be done at a certain time, then it's not. So I'll set you for 60 days. And then if your attorney gets information before then, and he wants to come back sooner, he can always set it. Okay?
Yes, ma'am.
All right, Ms. Ferguson, on this case, if I can have a 60-day reset, it's Luna. All right, so we'll be back on October 12th. Mr. Luna, do you have any questions?
No, Your Honor.
Okay. Yes, discovery. All right, if there's nothing else, you are excused. Court is calling 2021 CR 6159, State of Texas versus Andrew David Guerrero. Can I have parties announced for the record for the state?
Jason Garahan, Your Honor.
Defense?
Alfonso Cabañas for the defendant, Andrew Guerrero.
And are you Andrew David Guerrero?
Yes, ma'am.
I'm showing you what's entitled Motion to Revoke Community Supervision. Did you review that with your attorney? Did you understand it?
Yes, ma'am.
Are you the same Andrew David Guerrero who's placed on community supervision in 2021 CR 6159 for the offense of evading arrest, detention with a vehicle on November 19, 2021 for a term of 3 years? Is that you?
Yes, ma'am.
All right, state.
Yes, Your Honor. Violated condition number 4. In Bexar County, Texas, the defendant Andrew David Guerrero did then and there fail to report to the supervision officer as directed for the months of February and March 2022 in violation condition number 4.
How do you plead to that? True or not true?
True, ma'am. And Your Honor, we'll waive the remaining violated conditions.
Any objections to the waivers?
No objections, Judge.
All right, did you understand by pleading true to violation of condition number 4, court will find it true, the court could find it true, grant the motion, sentence you up to 3 years in the prison and up to a $1,500 fine?
Yes, ma'am.
Knowing that, do you still wish to plead true to violation of condition number 4?
Yes, ma'am.
Court will find violation of condition number 4 true. Is there a proposed agreement?
Yes, there is, Your Honor. And the consent did not deny the motion, extend the individual for 6 months and amend conditions to add state ISF cognitive behavioral track. And also have the probationer be supervised by the gang unit. That is also the recommendation by probation.
All right, counsel.
That is the recommendation, Judge, in conferring with my client. He's asking the court to follow a recommendation by the probation office.
All right, General, raise your right hand for me.
Yes, ma'am.
Do you solemnly swear and affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, ma'am.
All right, you can lower your hand, state your name for the record.
My name is Andrew David Guerrero.
All right, so why are you not reporting?
I don't have no excuse, but it was just around COVID and I was having hard times and that's it.
2022? That's COVID time? We were having court in 2022, were we not?
Yes.
And this plea was taken. Yeah, I don't understand.
I was just having a hard time and I'm just,
All right, so why are you people are always throwing COVID around?
no, because I mean, I was looking for a job. I couldn't find a job. I was just having a hard time.
But what does that have to do about picking up the phone and calling probation?
Well, I had COVID at that time and I was reporting, but my probation officer had stopped me from going in and I was just calling and calling. And that's it. And I just stopped.
Here's the thing.
I'm just not.
You can't be before me and being dishonest, because I tell you what I will do. I'll have probation zoom in and let me know what's going on. I know COVID doesn't travel through the phone lines and they're saying you did not report. That's a problem. So basically what you're telling me is that you had COVID for the months of February and March.
No,
So why are you being dishonest with me?
I'm not. I just.
Making up reasons
No, ma'am,
for not doing what you're supposed to do. Here's the thing. And this is what I've discovered in my time on the planet. When you do something wrong, you know what the best route is? Usually, I'm not going to get into legal discussions, but usually the best route is, I was wrong, I'm sorry. And guess what? When you say I was wrong, I'm sorry, the other person on the other end, if they don't accept your apology, then that's on them, but you've done all you can do. You can't go back in the past and mess with the time continuum and report. So why were you not reporting?
Just having a hard time, man. I'm sorry. I was just having a hard time.
All right,
I got
and
places to stay. Didn't have a job. I was just having a hard time.
what's with the drug issue? Do you have drug issues?
Don't have my dog.
Mhm. All right. Anything else from either side?
State,
Not from defense, Your Honor.
I'll deny the motion. I'm gonna extend you for 6 months. State ISF, cognitive, and gang supervision. All previous conditions remain, and that means the no contact with Brianna Castillo. Is there anything else?
No, yeah, that's fine, but I don't see how she's coming up if that was what. That was just a previous condition.
Because that's part of your conditions. No contact with Brianna Castillo.
Oh, okay. Well, guess not.
All right, is there anything else you need from the court to be successful? All right, and then probation upon release. I'm gonna want GPS and he's allowed to work. So it'll be partial for work. And that'll be until further notice. Is there anything else you need from the court?
No, ma'am, thank you.
All right, good luck to you.
Thank you, Judge.
You're welcome. All right, counsel, we're here today for discovery. It's driving while intoxicated.
It is, Judge. So, Judge, we were here, last time we were here, I need to get a discovery order on file, the blood discovery.
Mhm.
I checked on that this morning, found the order was in, the submission was in drafts on my e-file. We didn't get it in, and that's on me, Judge.
Okay.
And so if we could.
So do you have a copy with you today or no?
We're e-filed it, and I can bring you the copy for you to sign.
All right, so that needs to be done today.
Yes, ma'am.
Ms. Ferguson? If I can have a 30-day reset on Cox for discovery? All right, just sign the reset form, then your excuse.
Yes, ma'am, thank you.
You're welcome. All right, State, did you tender an offer?
yes, Your Honor. We did today.
All right. All right, Ms. Ferguson. On Alexander Castro. I need a plea deadline date in 2 weeks. All right, August 24th is going to be your plea deadline date. On that date, you need to let the court know whether or not you're accepting the state's offer. After that, the court will not consider any plea bargain agreements without good cause. Otherwise, you have to plea open to the court. Do you understand?
Yes.
All right, once you sign your reset form, you're excused.
Maybe excuse when we sign.
Yes.
Thank you.
All right. You all are asking for bond?
Yes, Your Honor. He has 6 cases, 2 of them where he's been remanded without bond. The original bond on each was 5,000, and I believe the district attorney has agreed to 7,500 on each. So apparently he was remanded without bond on July the 29th.
I can give you.
I'm sorry, June 29th.
I can give you some history, Judge. So on the 2 state jails that he's remanded without, Mr. Butler was appointed.
Mhm.
He's also appointed on the unauthorized use of a motor vehicle, which must be a different bondsman because Mr. Castro still shows as being on bond for those or for that case. The bondsman filed an affidavit of surety to surrender, which of course was signed by the court.
Mhm.
That's what triggered the remand without bond. While he was in fugitive status, he's alleged to have committed some new offenses. I got appointed on those. He does have a bond set on those, but the issue is he's still remanded without on Mr. Butler's 2 cases.
All right. So normally the court will proceed, but because he's picked up new cases, you all need to file motions and we need to have a hearing. So if you all file a motion and if the state has no objection, the court can hear it on Monday.
I'm on vacation on Monday.
Okay. If you want to appear by Zoom, you can, or if you.
I'm on an airplane.
Okay. So whatever date you all want to set it on. Okay. All right. Or if you all want to file a motion and we'll hear it this afternoon during break.
Not sure I have time to do that.
Okay. All right, just let the court know then when would you all, well, these are all night mag and CM numbers. So just set it with Ms. Ferguson when you all want to bring it back and the court will hear it.
Thank you.
Okay, you're welcome. Or maybe Judge Nahara will hear it without a motion, but I need a motion. Yes. I mean, he may hear it without a motion, but I need a motion.
Okay.
Okay. All right, you didn't successfully complete your pretrial diversion.
Judge, that's what the file shows. Ms. Hernandez believes that she did. Now, I contacted the pretrial diversion units. I didn't talk to her caseworker. I talked to somebody else and they confirmed she did not complete it. She still thinks that she completed. So what we want is a reset if we could. I want her to be sure. I want her to talk to her caseworker to get it from the caseworker. She didn't complete it. If she did not complete it, when we come back, we're going to do a plea. We have a plea agreement. And all we want is a short reset. When we come back, either we're going to find out the pretrial diversion was completed as a mistake, or she's going to do a plea.
All right, Ms. Ferguson. On Robin Hernandez.
I mean, just, am I correct? Is that what you agreed to do?
Yes.
And when you come back and take a plea, one of the part of the plea is you're going to go to rehab. And you'll go into rehab right then and there that day, right? And you'll be taken to custody.
All right, Ms. Ferguson, can we set this in 2 weeks for a plea deadline date? All right, your plea deadline date is going to be August 24th. Do you understand? They're going to give you a reset form and then you're excused.
Judge,
Yes.
it looks like I'm going to do a murder case on the 21st.
All right, let's do this.
So give me the Friday before or right after that week.
Norma, he's going to be in trial. So let's do this. Instead of doing it the 24th, can we set this for the 15th? Is that good?
For September?
August.
Oh, 15, yeah, sure, yeah, that's. Yeah,
Yes.
what's the day? Today's the 10th.
Today is the
5 days.
10th.
No,
All right, so we're going to do August 15th.
that's it.
All right, the court is going to call 2021 CR 4470, State of Texas versus Richard Thomas. Can I have parties announced for the record for the state?
Ruben Herrera for the state.
Defense?
Dr. Baez on behalf of the defendant.
And are you Mr. Thomas?
Yes.
All right, so counsel, you had sought to introduce into evidence defense exhibits 2, 3, 4, 5, and I believe defense exhibit number 14, is that correct?
That is correct, Your Honor.
And also defense exhibits number 12 and 13.
That is also correct, Your
All right. And the court had a 412 hearing, and today the court was going to hear argument for both parties on whether or not the court should allow those exhibits introduced into evidence, correct?
That's correct. That's correct, Your Honor.
All right. And we did have a hearing, and that hearing was in camera under seal. So, Mr. Baez, are you informing the court that you are withdrawing those exhibits and not seeking to introduce them?
Your Honor, that is correct. After doing some research last night and going through the exhibits again, and I was trying to hold for the exceptions to the 412, 609, modus, so on and so forth. And I don't believe I'm gonna be able to get there, not at this time. So as a result, Your Honor, we're gonna withdraw all those exhibits if we are allowed.
Okay, so the defense is seeking to withdraw defense exhibits 2, 3, 4, 5, 12, 13, and 14. Any objections from the state?
No objection from the state.
All right. And then counsel, if you believe that at some point in time, those are relevant and you're able to introduce them, that will still need to be done outside the presence of the jury. And of course, the court will hear whatever argument parties has.
That will only happen, Your Honors, as we see it, if the exception arises. But as of right now, we cannot.
All right. And then with regards to defense exhibits 8, 9, and 10, We were missing those.
Your Honor, I found them, the court reporter told me, and so she hounded me, she threatened me, no,
Okay.
and so I found them. Your Honor.
All right. And those exhibits were not offered into evidence. Those were just used with regards to the CPS caseworker. All right. Is there anything else?
Nothing from the state, Your Honor. I guess just in anticipation of anything going further, and that any allusion to any of those exhibits be brought up before the court outside of the presidential jury prior to going down any line of questioning.
If I believe that exception has to rise, I will approach the court. I will ask that.
All right. So we'll start the trial at 1 p.m.
Thank you, Your Honor.
All right. Thank you.
Thank you.
Thank you. All right. The court is calling 2023 CR 1876, State of Texas versus Yvette Martinez. Can I have parties announced for the record for the state,
Jason Garahan.
for the defense?
Jonathan Chavez for Ms. Martinez.
Are you Miss Martinez?
Yes.
All right. This case has been rescheduled more than once. And it was due to the fact that Miss Martinez, attorney that is listed on the record, Kenton Longacre, was unable to appear. And so it was reset for today. The court will note that each time this case has been set, the complainant has appeared. So the court informed Matt.
Yes, Your Honor.
And so what is the status?
Your Honor, the attorney who has been assigned, we have been unable to contact him for the past 3 weeks. We have spoken with both the state and Ms. Martinez, and we're comfortable with going forward with sentencing today.
All right, Ms. Martinez, are you prepared to proceed? You're gonna need to speak up.
Yes.
All right, and you're prepared to proceed with these attorneys?
Yes.
All right. So in this case, you entered a plea of guilty to count 1 on June 5th. The court requested a PSI and TAP evaluation. Have both parties had a chance to review the PSI and TAP evaluation, state?
Yes, Your Honor.
Defense?
Yes, Your Honor.
Any objections to the PSI or TAP evaluation?
No, Your Honor.
And I forgot to put this part on the record. Ms. Martinez, have you had ample time to speak with the current attorneys?
Yes.
Okay. You entered a plea bargain agreement. According to the plea bargain agreement, your punishment was to be assessed at 10 years in the prison. The state is opposing your application for deferred adjudication. They are recommending community supervision. There is to be restitution to the complainants in the case. And there are stipulations about your location. Did you understand that as the plea?
Yes.
Okay. Counsel, is there anything you wish to say on behalf of your client?
Your Honor, we just ask that you follow along with the plea agreement of the 10 years probation.
Okay. State?
Your Honor, the state is in agreement following the rec here, Judge, opposed to the deferred, and also to follow the tax recommendations.
And that's correct, Your Honor.
Okay. All right,
Your Honor, may I speak with may I speak with the client real quick?
yes,
Thank you. Something's just been brought to my attention.
Okay.
Just a brief moment.
sure.
Final result. The court moves forward despite the delays. Instead of prison, the defendant faces 10 years of community supervision, restitution, and strict conditions. One mistake during probation could trigger the full prison sentence. Like, share, comment, and subscribe for more courtroom breakdowns.